Welcome back to the afternoon sessions of the 4th Belt and Road Conference. I am Corinne Wong, Council Member of the Law Society of Hong Kong. My co-host is Daniel Leung, Member of the Belt and Road Conference Organizing Committee. It is our pleasure to facilitate this afternoon's sessions today.
Without further ado, let's now begin our discussions on Session 2. How law and legal professionals can help business to maneuver in geopolitically troubled water. Business do not operate in a vacuum from politics. How can we lawyers around the world help business navigate geopolitically risk sanctions, taxation in the digital economy, trade war, currency war, resource crunch in an evolving new world order? We now have a wonderful opportunity to hear directly from our fellow bar leaders from different jurisdictions on how they perceive these issues. If you have any question to our speakers, please write down on the question slip in the conference folders and hand it over to our staff, or to type your questions in the Q&A box during or after the presentations.
Now, please join me in welcoming the panel chair of this session, Mr. Hyun Wong, BBS JP, past president of the Law Society of Hong Kong, to the stage. To join Mr. Wong for the discussion, please welcome, we have guests on the webinar, Mr. Lawson Chan, Vice President of the Guangdong Lawyers Association, Mr. Konstantin Dobrynin, State Secretary of the Russian Federal Bar Association, Mr. Jerome C. Roth, immediate past President of the Union Internationale des Avocats, Mr. Albert Zaw-min, General Secretary of the Myanmar Bar Association. So without further ado, to our panel chair and speakers, please.
Thank you, Alice, for the introduction. Hi, everybody. Welcome back. I say welcome to those who are attending physically here in the hall, and of course, all those who are joining us virtually online. This is a very exciting afternoon because we have two more topics which are absolutely topical and soul-searching, and I'm sure it will be very inspiring to a lot of us here as well. Now, the first session we have now, the title is already mentioned, but I repeat, how law and legal professions can help business to maneuver in geopolitically troubled waters. People say that we lawyers, we love troubles because trouble means more work for us. It may not be true. But one thing is true. It's been suggested that lawyers have a professional interest in politics, partly because I think the profession is so compatible with a political career. Because lawyers and politicians normally are expected to be very eloquent, very business mind, of course, but they also have to possess good political sense and good presentational skills. And then they also have a highly analytical approach to issues, and they also are capable of coming up with good solution to problems. And very often, they are very good in reaching compromise, finding middle ground, and make parties, all parties involved can come back with whatever they want and feel happy. That is what politicians and lawyers are fighting to achieve. This afternoon, we are so lucky to have 4 distinguished speakers from different jurisdictions to share with us. In this business do not operate in a vacuum, right, from politics. Now, we lawyers, how can we, from all around the world, as I mentioned, the 4 speakers, help business navigate geopolitically risky business in face of all the taxations, sanctions imposed by one jurisdiction against another, and all this digital economy? We talk about digitalization and digitization, right? They are not the same thing, but both are suggesting that we are entering into a new digital world. And all the currency war, trade war, resource crunch, etc., and I think it's about time we lawyer did something about it. And now we are going to spend the next 1.5 hours to explore the way we can help. Now, may I invite each of the 4 speakers to quickly make a brief presentation of his point. And I would like to give each of you no more than 12 minutes. I'll be keeping the time, I will remind you. And then we will start opening the floor. Then each of you can ask the other speakers any question you like. And then we open the floor to our floor, both virtual and physical, right? So if any audience online would like to ask a question, please feel free to type it in and we'll raise it to the speaker. So without further ado, may I now invite our first speaker, Mr. Lawson Chen. Mr. Lawson Chen is the Vice President of Guangdong Lawyers Association. He's currently leading the development of foreign-related legal services in the Guangdong province, which for some of you, the Guangdong province is the southmost province within the mainland China. Mr. Wong facilitated the establishment of domestic and foreign legal professional cooperation and exchange platforms. Mr. Chen has a close connection with legal professions in Hong Kong, Singapore, Kazakhstan, the United Kingdom, and other regions, and has been invited to participate in various large international legal forums and seminars. So he is no stranger in giving seminars. I'm sure you will enjoy his presentation. Now, Lawson, are you ready? You will have 12 minutes. I'll hand over to you now.
Thank you. 非常感谢主持人还有
Thank you very much, moderator, and also guests. I'm very pleased to have this opportunity to take part, and I'll be speaking in Chinese to introduce the subject. I believe that today's sharing session is very meaningful, and therefore I'd like to share with you my views on this. Moderator, please. So can you share the screen or PowerPoint with us? Well, sorry, we haven't really switched on the share screen. So our technical staff, please help with the sharing of the screen.
To work on your share screen so that we can all read your PPT. I think they should be coming on screen pretty soon. But otherwise, we are still in a digital world, Mr. Chen. There you are. Oh.
找到了，但是现在好像，等一下。
Interestingly, the two monitors facing me, they're all right. Yeah, okay, good. 可以了
OK，
Mr. Lawson.
All right. It's okay now, Mr. Chen. All right. Okay. The theme of today's discussion is about compliance. It's a firewall under complex global situation, and I'll be dividing my speech into 3 parts. First is about the importance of establishing a compliance management system. Second is about the establishment of a compliance management system. Third is about suggestions on compliance of international trade. And I'll be looking at this from the Chinese perspective as a Chinese lawyer, and also from the Chinese enterprises' experience. In fact, we are now in a very major era where there are major adjustments and transformation, and therefore there have been a lot of changes.
At the moment, the globalization of the economy is developing very quickly. And at the same time, the world faces huge instability and uncertainty. And with Huawei and other companies that in ZTE and all that, they faces uncertainties in their international business. Now, they're facing such changing circumstances. What kind of help does the enterprise need, and what can lawyers like us do for them? Now, I believe that compliance is the foundation of steering in wild waters, and it is also the lifeline of enterprises, and it is also protection for the companies. Good compliance protects the company when the government is pursuing the company, and so that the companies indeed can protect its assets and its rights. In April 2020, the Supreme Procuratorate of China had proclaimed a work pilot work, which is a lenient policy, which tries not to pursue to sue the companies that are willing to be compliant and would go for self regulations. And so these enterprises can take this as a very important thing, and in return would save itself from suffering from penalties. Now, in China, we already have a compliance guidelines, and that applies for domestic as well as foreign companies. And the Ministry of Commerce and Ministry of Finance already has proclaimed its rules. In 2020, the State Council had proclaimed the compliance guide for SOEs. Now, all of these guidelines clearly points out that a good import and export compliance needs to first proclaim its declarations and standards, and also it needs to be subject to comprehensive evaluation, and also it has to have good education and training. It's subject to audit, and it is also necessary to produce guidebooks. So good companies needed to follow, to protect, and to implement on these policies. And when they execute on compliance pursuance, they needed to self-review in a timely manner. Now, upcoming, I'd like to talk about the cross-border trades of Chinese companies and what are the risks and challenges that they face in the course of doing business. The first one is about export control. As far as export control is concerned, the traders faces compliance risks. We have to build a blacklist of traders, and also to pursue the compliance of these companies, and also to form a list of the subjects and the commodities that are being traded, to make a good list and a bad list. And the blacklist can be categorized based on the different countries that the companies are coming from and the industries that they work in. For example, the MOF has its own unreliable list, as well as the Ministry of Foreign Affairs has its own list, and also the USA has its own list, etc. Now, all of these data needed to be managed, and based on the timing, the scope of these data, the export products and export companies and the export documentations, etc., all of these has to be managed. Now, secondly, as far as national safety is concerned, let's take USA as an example. When the companies invest in the USA, it is subject to the authorities in the US for auditing. And we need to help these enterprises to evaluate the risks ahead of time. And that includes the trading time, the trading subject matter, and the trading scope. And at the time of trading, we needed to anticipate the audit time that is needed. As far as this is concerned, there are a lot of companies that are now put in stalemate as far as business is concerned because of such a timing lag. And over 50% of Chinese companies are now falling into this time gap, which means that one needs to allow for at least 4 to 6 months for such audit and application procedures. And also, the U.S. authorities for key technologies and key areas of investments, they attach a lot of importance. So it is very easy for it to be justified or to be identified as a company that impacts that is negative to the American national safety. Now, for foreigners to directly or indirectly obtain sensitive information of the U.S., the traders need to announce themselves. So SOEs need to, when they do the planning, they need to plan well for the entities that go into the trading. And also, as far as policy is concerned, there are scenarios that present data risk. For example, the way that data is collected and the internal audit of the company, how are the data transmitted to the headquarters or related companies. Now, these may not be compliant with Chinese law as well as U.S. privacy laws. So one needs to remind these enterprises that if they are being subject to investigation of the domestic as well as U.S. or foreign regulators, the companies must not only take care of the domestic regulators' view. They must also take into consideration the foreign regulators. And also for the foreign customers and third-party companies, when transmitting data to them, risk assessment and safety assessment needs to be done to make sure that compliance is both for domestic as well as foreign laws. And when transmitting different types of data, before the data is transferred, when it is saved, it is also subject to the compliance regulations of foreign regulators. So from when domestic companies show or share important data to a foreign company, it can also be not compliant to the laws. And also, this is not included only for domestic laws and regulations. It is also applicable to rules, standards, and industry practices, etc. So with changes in strategy, it can be very frequent. So lawyers need to remind companies to be highly regarding or highly alert of such changes, both domestically and internationally. We need to help companies identify the risks, and lawyers can familiarize themselves with the policy documentations, as well as the security, political, and cultural circumstances of the invested countries. And post-investment risk management must also be done well. So for places where the system, there's a lack of transparency and system equity, one needs to balance and evaluate the risk well so that it is within control. Now, all in all, the companies needs to work closely with lawyers and to place close attention to the risks and to update the blacklist of export, and also be familiar with the auditing regulations of the invested country, and also attach a lot of importance to the building of compliance mechanism and procedures internally. And one needs to have a strategy to fight for such uncertainties. So in the last couple of years, the Guangdong lawyers industry, under the guidance of our leaders, had been cooperating and communicating with Hong Kong. And we have also initiated the Bigger Bay Area lawyers legal network, so that the lawyers from the different places can work in within the entire region. So I hope that upcoming we can build a network that is formed by lawyers from the Greater Bay Area as well as lawyers from the Belt and Road countries, so that we can help companies to maneuver such unstable waters steadily. Chinese lawyers understand Chinese laws. Hong Kong lawyers understands common law and also understands China, so they can serve as a very good bridge. The lawyers from Taiwan has a commonality as far as their law is concerned with Chinese law, so they can work together to lead and to consult the companies with a stable legal knowledge, forming a team themselves to help the companies navigate these uncertain waters when they invest and when they trade along the Belt and Road and Greater Bay countries. These are my sharings.
Join me to give a big hand to Mr. Lawson Chan. We thank him for his very insightful analysis of the situation. Especially, I think we can't agree more that these days, the best protection we can afford to our client as a lawyer is to advise them on compliance. And compliance is such an important subject, and for all multinational companies, and as their legal advisor, this is one area we need to pay most attention to. And also, this is the part we can contribute towards a better harmonious relationship between nations, because very often this so-called long-arm legislations very often is a product of competition between sometimes basically trade war, but also competition between different nations. So as a result of this long-armed legislation, we have a lot of trade barriers, a lot of pitfalls, man-made pitfalls built between nations, and sometimes there could be landmines buried under the ground, and we have to tread over these dangerous landmines carefully with our clients. So nothing more important than compliance. We understand the local legislation, we explain them to our clients, we help them to circumnavigate along these landmines or unknown, uncharted area. All this will show lawyers could be extremely useful. And this also was one of the main points we want to bring home to everybody in this afternoon. Now, let the discussion continue. Our next speaker is Mr. Constantine Debrulin. Constantine has been an official representative of Pen and Paper in London since March 2019. He represented the Akhanko region for 4 years as a member of the Federation Council of Russian Federal Assembly and as a deputy chair of the Federation Council Committee for Constitutional Legislation and State Construction. He was plenipotentiary representative of the Federation Council of the Russian Justice Ministry. And he is one very good linguist. He speaks several languages. And he served as the State Secretary and Deputy President of Russian Federal Bar Association. So he must have a lot of knowledge in international relationships. And I can't wait to hear from Konstantin. And now may I hand over to you, and please share with us your views on how lawyers can help business to maneuver in geopolitically troubled waters. Over to you, Konstantin.
Thank you for such a beautiful introduction. Honestly, I know just two languages, Russian and English, so I'll try to use English.
I thought you can speak more, right? Well, you can speak it.
Maybe next, now I have a challenge.
Highly recommend Chinese, sir.
Okay, I'll try. My little son, he was trying to teach Chinese, maybe than me. Oh, my dear colleagues, as the State Secretary of Russian Federal Chamber of Lawyers, and like a normal attorney now I'm not a politician. I'm very glad to virtually greet you at this friendly legal event. It's good that even at these dire times and challenging times, we can discuss such an important issues about our legal profession and about our rule of law in modern and very cold, unfortunately, pandemic world. Because, this COVID-19 is like an invasion which definitely perplexed our normal life and the whole legal business and political world, therefore. First year of fighting pandemic was erratic, and I mean not only medical measures, I mean legal measures which were undertaken by all governments, not only by Russian government. And some of that measures were incapable to protect the people. Moreover, some of the measures were and legal mechanisms were sometimes consensual and untenable. But what is more important, it's current risks which we lawyers do have in a moment and which could jeopardize the rule of law and therefore could jeopardize the business as it is. I would subdivide this risk in two groups. First group is political and economical risk. Because COVID-19 has deeply impacted the business all over the world. It would definitely influence the political situation and political risk. Because every country is trying to find simple legislation decision. Sometimes this decision could ruin the basic human right. What we do feel in Russia sometimes that government trying to use pandemic in their own interest to make more legislative restriction which could stay in our life permanently even after pandemic will pass. Second group of risk, it's a professional attorney risk, and we all well known about that. But this risk is what we call pandemic atmosphere, and but it's not the main threat. Less than a 6-year passed since I stopped being a senator for the upper chamber of the Russian parliament. But even when I used to be a senator, I didn't really think that relationship between the countries, situation in legal world, will reach such a point, such a sad point. It's obvious that our profession is underestimated, and I don't mean the business of law. I mean another very important aspect of our profession. That is the supremacy of law and the importance of lawyers in the modern and very cold world. The world which reminds me the cold years before the perestroika in Russia. The world which we lawyers see as it is, including the seamy side of life. The world where law still doesn't unite as it can and should. It's new Cold War we face in international politics now. And the economy is completely influenced by this, and not in a good sense. And the law is now kind of a hostage of first two, I mean political and economic. Why? Because forms of legal conscience, both in Russia and in West and in East, are taken on exotic, quasi-legal forms. In reality, we are dealing with a new and fundamentally different type of legislation, sanction and counter-sanction law, and compliance as it is. This law consists both of criminal law, international public law, international private law, and even state law. So it's a new product which we lawyers are dealing with. And this new law is a great challenge for us, but this is a professional challenge. But the main problem we people of law face is the difficulties of translation. I mean the difficulties of translation from human language into the language of law, from the language of politics into the language of law, from the language of the state into the human one. And this problem exists because everyone has their own truth. And we lawyers are born to try and find the universal common ground and comprehensive common language. So it really doesn't matter what language we speak, Russian, English, Chinese, or Arabic. The people of law possess the common language of law. What should a modern lawyer be? First of all, this is a person who can protect the rights and reach an agreement when the sides cannot do it themselves, no matter what they are, citizens, politicians, or states. We not only works out rules and laws, do practice, help people, we also build the bridges of law. These bridges not only help us, all of us, not help the market of law to be more effective and useful, but they bridge the gaps between the countries and continents. So these bridges can give an opportunity to unite even to those who are not ready to do it now. That's why I think the law, it's not about business, it's about human beings. So my answer on the pointed question is, we lawyers shall help not to maneuver in politically troubled waters, but help to build a proper, solid way. Let's call it bridge of law. Thank you, my friends.
Thank you very much. Thank you. Yes, I thought at one point of saying that there's only one language for politicians, wherever they come from, right? The West, East, they all speak politician language, right? They all speak politician rather than speaking language. But I think we get your point. Our job as a lawyer is to bridge between this, the law, the letters of the law, and how the law is applied to our clients, to our business people. And most important of all is to break this invisible wall built by politicians between nations and between people doing business. And we have to do our service to assist our client to again break through the wall and reach out to our the other side of our business deals. Okay, thank you so very much. And also, yeah, your view on rule of law is also shared by everybody. The rule of law has no language. This is universally applicable, and it should be equally applied in all nations. Under any system whatsoever, be it you call it common law system, civil system, the rule of law is still the same. Thank you so very much, Constantine. Now that leads us to the next speaker, talk about linguists. He is real linguist, a modern linguist. It's more almost like a translation software, because Jerry Robb is a partner of Munger, Tolles and Olson in San Francisco, where he specializes in business and international litigation, arbitration and mediation. well, he has all the qualities, attributes to being a very good lawyer to assist achieving a harmonious business world. Jerry also represents European, Asian, and Latin American clients, as well as U.S. companies in matters abroad. He is ICC trained, he speaks French, Spanish, Italian, and he also works in German and Portuguese. Phew, pretty impressive, right? Jerry holds a French language master's degree in international European and French business law from Université de Paris. He is immediate past president of the Paris Space Union, UIA basically, and then the world's oldest international lawyer association. In that capacity, he worked with global bar leaders on substantive legal issues, including mediation and protection of the rule of law. Right. Without further ado, I would like to hand over to Mr. Rothers and for him to make a presentation for about 12-15 minutes. Then, before I would like to ask him some question later, of course, right? Okay, are you ready? Shall we over to you, Jerome?
Okay, thank you so much, and good morning from Paris. First of all, I'm so honored to be here today. UIA, or the Union Internationale des Avocats, the International Association of Lawyers, greatly values our relationship with the Law Society of Hong Kong. I participated in a panel there in January 2020, right before the lockdown, and I remember it well. I've worked with Melissa Pang on many, many different events. She has spoken at the UIA several times, and I so wish I could be there in person now. I also wear a second hat that is relevant to our topic today. I'm an American lawyer, and I'm a member of the Bar of the State of California. And I was really gratified, I have to say, to see the topic of this session, because I consider it to be of really the greatest relevance to lawyers around the world. And yet, it's a subject that is not sufficiently discussed, in my view, in an open and candid manner among lawyers, because it touches, it sort of starts edging into the political world, and so people shy away from it. And yet our clients are, of course, dealing with it every single day. There's no doubt that the law and lawyers have a critical role to play in light of the troubled geopolitical realities that surround us as we approach 2022, almost a quarter century into this new millennium. And that's especially true in a world that seems to be, and I'm interested in others' perspectives on this, but from where I stand, increasingly divided into spheres of influence in a way that we haven't seen in many years. You know, at least two, obviously, with competition between China and the United States, which becomes more and more open on many levels each day. A third player, Russia, Konstantin's country, which obviously is a very significant player and more willing to use its energy resources and related economic clout in international affairs. We have a rising India. We have so many things going on in terms of regionalization. And it's not limited to just those large countries. I mean, we see constant shifts and realignments within all parts of the world. In Europe, Brexit is still roiling everybody, causing real concern among so many countries. We recently, I'm sure you followed, had some tensions break out between France and Australia and the United States about a submarine transaction that caused a whole set of issues that affected U.S. clients doing business in France and French clients and Australian clients doing business in the United States. So these issues come up in unexpected ways. And of course, all of it is exacerbated by COVID, as Konstantin mentioned, a phenomenon that has really shown us some differences between regions, created some disputes between regions, and yet brought the world closer together by video, like my being able to talk to you right now, which we would not have done a year or two ago. So we see both aspects of what COVID has done for us. You know, there have been a number of really fascinating academic analyses recently about a shift in geopolitics, viewing the world not through only the prism of national states on the one hand, or through universalism and humanity on the other, but rather through this prism of regions or spheres of influence. It's not exactly like 19th century colonialism. It's not 20th century Cold War, but it has aspects of both of them. And it means understanding not only national and universal principles, which I think lawyers tend to do, but also making sure we understand regional differences and regional principles and understand the perspective of other regions that are not our own. We can, of course, it's easy to think about that in terms of East and West, but there are plenty of others. You know, I grew up in a common law system, but I've studied the civil system quite a bit that reigns in France, Germany, and it's implemented so differently in different regions. If you don't have your eye on regions and geopolitics, you're missing something very important. South America has a civil law system, but it's very influenced by the United States. Asian countries have mostly civil law system, not Hong Kong, of course, very influenced by China. East Asia, very influenced by Russia. French Africa, very influenced by France. Arab countries by Sharia law, and in English-speaking Africa by the common law from the UK. And for lawyers and the law, we really need a clear, calm, consistent way to help our clients negotiate their way through these new regional realities. And I think about it in sort of three areas: litigation, corporate, and then what I would call sort of principles and human rights, the rule of law, some of the things that we've talked about, earlier. In litigation, we think about our clients are often worried about making sure that they're getting a fair deal in front of a foreign court. I can't tell you how concerned an American company is if it ends up before a Chinese court or a Chinese arbitrator. I understand from the comments of Mr. Chen that a Chinese company has exactly the same concerns when it ends up in front of a United States court or arbitrator or the Department of Justice, as he spoke about. And Mr. Chen, I only understood what you wrote in your slides because I didn't have a translation, but I think I got the thrust of your point on that issue. I understand it, very well. And another growing concern, if I can be frank, in terms of litigation, is whether the positions lawyers take for their clients may impact their work, their clients' work, and may politicize things in other ways. I mean, I've just recently read about Mayor Brown's issues in Hong Kong, first criticized by one group for a position it took, and then when it changed its position, criticized by the former government officials. So think about that law firm trying to negotiate its way through what is frankly a geopolitical issue in many ways. How do lawyers and clients make decisions in litigation that can have unintended impacts on their business, on their law firms, on the way they're perceived in one region or another? And it seems to me that lawyers have to play the critical role of trying to see things from the perspective of the other side in a way that our clients sometimes don't. If we can't do that, if we're not able to explain to our clients how the other side might perceive something we do in litigation, we're not doing our job, in my view. In corporate law, we see clients worrying about their business interests abroad, how those might be interests, where should they invest, what risks do they face. Recent crackdowns on some Chinese companies in the United States, recent crackdowns on tech companies in China. I just read today that all of this may have given new impetus to corporate transactions in India, sort of just to get out of this tension between the United States and China. And companies considering leaving one area or another because of different regulatory environments and the perception of geopolitical factors. Again, lawyers have a key role to play in advising on these issues and helping companies understand the perspective of these other regions that they're working on. They cannot Oftentimes, clients just do not have the perspective that I think lawyers who have a somewhat more globalist and sometimes more regional, as I hope they should, view can help explain. And then there's the issue of values, human rights and the rule of law, things that Constantine talked about. I see this in a lot of areas, media companies where some regions are willing to impose speech limitations, both on our side and both in the West and the East, that run up against values of free speech, manufacturers that face supply chain issues arising from working condition of laborers who supply goods and services. Businesses in the U.S. worry about how to deal with those controversies abroad. Businesses outside of the U.S., I know, worry about how they will be perceived in the United States. Bowing to or complying with, to take Mr. Chen's point, one government's demands in one region can cause blowback in another region with differing values. That's a big problem for a client. I think Mr. Chen referenced that. If one country says you have to produce these documents and the other country says if you produce those documents, you're violating our law and you're violating domestic law, you put the company in a no-win situation where lawyers' advice is absolutely critical. And at the same time, companies have to answer now to their boards, to their employees, to their customers about the role the company plays in protecting the rule of law and human rights. So in all of these areas, lawyers are asked to guide their clients to tease apart what is legal and what is political, because the overlap, those fine lines, really are difficult to see and cannot be avoided or ignored. And they have to be confronted with open eyes and honestly and candidly. And I tell young lawyers at my firm really to follow 5 guidelines. 1, be aware of national differences and regional differences and try to see the perspective of the other side. Follow economic news and political news so you're aware of what's going on, because these issues are changing every day. Help companies figure out what their values are and what lines they are willing to cross and not willing to cross, how they should think about that, what they're willing to do and not willing to do, and discuss it frankly. Recognize that nothing is without consequences. Once you make a choice, there will be a reaction. A value you try to impose on others may be imposed on you in a way you don't anticipate. Be willing to accept the consequences, be aware of the consequences, and be willing to accept the consequences of your actions. And very importantly, I think lawyers have to balance giving the right advice to their client with being true to themselves. They have to find that line between their client's interests and their own personal integrity. That's what we've got. I think Constantine made that point. That's what we're all about. And the geopolitical context forces those issues forward in a way that I don't think has happened in the past. So with that, I just couldn't be happier to be here with this group and such a diverse group from different regions to discuss and share these issues. And I really look forward to hearing what others have to say. I really enjoyed Mr. Chen's comments and Constance's as well. Spasiba, and thank you, and sheshe.
Thank you. Thank you very much, Mr. Roth. Yeah, I mean, it's absolutely fascinating to hear this type of approach, because we talk about the firewall is to help. In a way, we have to accept that the impediments are there. Things have been put on our way, and we will have to somehow overcome. But is the direct opposite, is that, look, why don't we look from the perspective of the other side? You then probably see that there may not be any impediments at all. Maybe these are just different views looking at the same thing, and of course we will have different perception. We think that you're making things difficult for us, but the other side that we are being very reasonable because we do need to protect our national interest, things like that. I think it's all that boils down to, at the end of the day, as a lawyer or as a good politician, we will have to find a way to resolve this. We can always look at things from the other perspective. There's a very, very ancient Chinese saying, which is more or less the same. You should understand an issue from your opponent's point of view before you come to any conclusion. I think that must be the best way. I'm sure there is a lot lot to discuss when the presentations are over. But in the meantime, we must continue with the presentations, and we'll leave plenty of time for all the audiences and also among our 4 presenters to discuss these very interesting soul-searching issues. Now, our 4th speaker is Mr. Albert Saw Min. Mr. Albert Saw Min is the General Secretary of Myanmar Bar Association. He is also the founder and president of Myanmar International Arbitration Center Incorporated and a joint secretary of Intellectual Property Proprietors Association of Myanmar. He's very experienced in various legal consulting services type of work for 30 years. He also has been practicing as an advocate and providing legislative advice and a bill drafting service to union and regional state government of Myanmar. Wow, so he is not only practicing law, but he also helped drafting the law. Local professionals practicing areas covers a broader spectrum, including maritime, aviation, insurance, and reinsurance, corporate partnership, labor, real estate, P&I club disputes, and IP. So he specializes in solving contractual agreement and dispute and is familiar with Myanmar legal framework and litigation proceedings. Right. This is the right time for me to introduce Mr. Albert Saw Min. Okay?
Yes, okay. Second, I want to brief about for our country. The second slide. Was it Myanmar is the second largest country in the South Asia. So and also we are surrounded by the Thailand, Bangladesh, Laos, and the 2 big population countries of China and India. And then we also has some the.
Sorry, Saw Min, we haven't got the screen on yet. I think Mr. Saw Min is already on page 1.
That slide.
Slide 1.
That's slide 1. We have the riches in natural resources like the gas, teak, agriculture, fish product, and the food slide. And we also the gold deposit and mining product. And the fifth slide, okay, I want to be the role of the lawyers and the judiciary in Myanmar was established during the British colonial period and continued after the Myanmar gained the independence in 1948 until now. So, regarding the how can help the business to maneuver in the geopolitical and troubled waters, I like to point out, I studied this, the previous dispute settlement, there's 2 teams, the Bangladesh versus Myanmar and the Sudanese versus Egyptian. So can you please see another, I think slide number 6, Bangladesh and Myanmar solve long-standing maritime dispute. This before the dispute, Myanmar and Bangladesh, they make a soft attempt to reach a bilateral agreement for loan and finally, ITL as the International Tribunal for the Law of the Sea can make the final verdict on the 14 March 2012. And firstly, I want to point out that before that, Myanmar have also have the because of these based on the natural resources, so that they can get the foreign reserve and they can make the export and they can get the business doing. So one is the trouble water. The further is based on the natural resource and some other kinds of the methods. So and the Bangladesh. After that, Bangladesh can get the negotiation. It can get the 111,000 square kilometers exclusive economic zone easily. And the dispute is how many years long? 38 years, and finished on the 2012. I don't want to be so long. Okay. And then these trouble the water I observed already. These are the base points on the east side coastline. In order to avoid the cutting of the Bangladesh from the other regions of the EZs, and also the potential 200 nautical mile EZs of the Myanmar. So finally, the ITLOS make a drawing. I will show you the map, okay? Can you see the map, Bangladesh? I think slide number, I forgot. They make the slide number, I think how many slide number? Slide number 10, slide number 10. Okay, slide number 10, you can see the square map composed by ITLS, illustrated. The gray area, no, you can see the gray area. Gray area is the upper, the seabed. No, seabed is the jurisdiction by the Bangladesh, and the Myanmar is there over the water. Very short time. Or that one is the dispute resolution after the ITLS and make the illustration of the map, and then this Myanmar and the Bangladesh, the boundary, the conflict are finished already. And another one is the my study this I see on the 1959 12th slide, the Nile waters agreement in the Sudanese and Egyptian relationship. They also based on the also my observation is based on the also resources. Because of, you can see in the Egypt in 1952, the free officer, they plan to make the high dam. The high dam, so that the high dam construction of this great dam got implemented, and the agreement on the allocation with the Nile's waters and the composition, they have the composition paid to the local people, the Wadi Laful of in the Sudans. So after that, they can make they can make the reservoir of the high dam. Finally, I want to tell you that the Nile River is the longest river in the world, and also Egypt and Sudan, they conquered long ago, and then after that, finally, what they can make, they make their context, their party, what they're doing, cooperation and understanding with respect to their socio-economic development needs. Based on that, they can make the dispute resolution. Another I want to show, another one is the China. Okay. Slide number 15. Slide number 15. The total dispute between China and the Philippines with the global implication. And that is also United Nations arbitration court will soon the rule over the sovereignty of this island in South China Sea for the territorial disputes China versus Philippines. China is still here asserting the claim in the region and has built atoll and the island to be large enough to stage military exercises. Because of this, South China is the major economic and geopolitical significance with its vital commercial lane, rich fishery, and massive natural gas and the oil deposit. That's why this is the complete, and also the business line also sometimes they cannot make each other. So that China is always reject in the UN process and argue that the Philippines should seek to settle the dispute negotiation like us before. So yes, meantime has been studying other military exercise in the South China Sea and coming in the recent months. And we can check what is the background, the tension. The tension background, what we are likely going to see, implication and consequences. What implication, what consequences based on that? And we have to see, we have to be retrospect that China is an economic success, not just now, and obviously in the past 25 years ago. So it's grown up, and also China lifting the million out of the poverty in the race of the economic growth and parallel in the modern world. So that's why China, its position is one of the world's preeminent centers of power and influence. So that's why the China claim the white or the sway of territory in the South China Sea is all often shown on Chinese maps in the 9 dashes and indeed refer to what was they want. And then we like to explain in the brief that the exclusive economic zone is first introduced in 1982. The Convention and the law of the sea are area where the state can claim exclusionary rights over the marine resources. So every country has a limit of 200 nautical miles, 370 kilometers from the coastline. The seaward edge of its territorial sea. That's why easy overlap as in case some parts of in the South China Sea. It is up to the neighboring state in question to delineate order. Please on the slide 19. Part of the China strategy and the water of the South China Sea, the Liang over Iceland, natural and artificial, in order to establish sovereignty to claim these surrounding waters. But we can see that China territory claim overlaps with EEZs of Vietnam, Philippines, Malaysia, and Brunei. Even of the ongoing dispute over Iceland in South China Sea. And we can also see the Scarborough Shoal, a 60 square mile chain of the rocks, and the reef is claimed by both China and the Philippines. Okay, and the 20, slide 20. So, the area in October 2015, the year's warship passed within the 12 nautical miles of the China artificial island. The eroding wave likely create more problem than solution. So that's why China reject UN resolution. So in response to, we have to take contribution to the JANE, we now entitled as Hiding Theories, Troubled Waters. And we have to view, this is my observation, the final view of the international relations theory may prove useful in conceptualization, transboundary water management and politics is a fact. So, my suggestion to point the law, to follow the law and the legal practitioner should be S, based on application of IR theory from critical geopolitics, political ecology, and the social protection of nature. Second, increasing our use of the international political economy IPE and the International Social Security Agreement ISS. The depoliticization of ecology factors. The fourth, the role of the water management body and treaties. The fifth, international water causes which further analysis is needed to understand the unique role that treaties play vis-a-vis other cooperative measures. So in conclusion, this allows page 22. To conclude, bilateral negotiation and cooperation on the international political economy and international social security agreement that can be held business to maneuver in the geopolitical troubled waters. Thank you.
Thank you very much, Albert. Yeah, thank you for pointing out at the end of the day, all these territorial disputes, the case you referred to, like the International Court of Arbitration, it's already happened a couple of times that nations did not accept the arbitration award as enforceable, including America, including UK, for that matter, China as well. But then eventually, they will achieve what the award wanted to achieve is by doing what you had just mentioned, by bilateral negotiations, right? That will be the best solution, and that is also where the lawyers come in to help. And this is a very good suggestion. And regarding IPEISS, these are all in the spirit of cooperation, and also in coming up with IPEISS, lawyers have a lot to, has an important role to play as well. Okay, then we now finish the presentations of our four distinguished speakers presented. We now like to discuss generally over this many issues. We all boils down to the same thing. We are now talking about the Belt Road initiatives. Part of it is that the initiative started in mainland as to how we can achieve global recovery and harmony, and by following the Belt Road Initiative. Is it possible? And if so, to achieve that, what role the players should play? And that is what we are here, why we are here to discuss, and what we are here to discuss this afternoon. May I first ask, let me see, why don't we ask Mr. Chen, you're the first presenter, would you like to comment on, of course, you had brought home the point as we have to pay most attention on compliance. And as a lawyer, right, a compliance lawyer is why it's hot like a pancake. Everybody wants compliance lawyer these days, right? Because it's so important, and that is also the compliance department is the most powerful department in a company. Now, that, as I mentioned earlier on, is a very reactive approach. Is that you put up all these barriers, all the fences, I think of a way to circumnavigate, right? Get around it. But then I think Jerome is think of it in a different way. Is that when somebody put up something like that, somebody seemed to be unhappy about certain things. They put up some offensive, defensive. Can we not think of it from the way that, look, if I try to understand the situation from my opposition's perspective, would that make things easier? You can see that Jerome is obviously a very successful mediator as well. So that must be the spirit of the day. Mr. Chen, Lawson, do you think it is possible? Should we do it, as a lawyer, should we do it this way? Should we approach the issue by adopting such attitude?
I do agree with Mr. Wong, because in normal international trade, I think we should enjoy more economic transactions, and there shouldn't be too much interference from politics. I think we should be talking business, and we should do a better job in economic trade activities. However, I believe that different countries have their own political system and their own consideration concerning political security. So when it comes to Belt and Road and global trade and development, we must respect the political system of local countries, their laws and regulations, and their orders. There's an old Chinese saying that we should follow that place's customs when we go to a certain place. So when we are in a certain place, we should sing the local folk songs in that area. So in order to do business globally, we should first respect the host country's systems. So we should take the initiative to comply with local laws and regulations. We must be law-abiding enterprises. Of course, in the trade process, I'm sure enterprises will come across unfair treatment and practice, and there may be certain policy barriers. So I think we should take the normal route, especially for lawyers. Well, we should make use of certain routes and avenues to reflect these barriers and to break through these barriers so that we can have fair trade as a result. And in the global economic and international order, I think we should go through, for example, international organizations like UN, WTO, and other international organizations to build a fair trade order. So I think that would be advancement in legal civilization, and we can all prosper together. And then we can actually build a common system, sharing the same fate and destiny, and then we can enjoy economic prosperity and advancement. With this kind of attitude in doing business, I believe many problems can be solved. Of course, now we have mitigation, mediation, and arbitration, which are good ways to resolve disputes. So these are my suggestions.
Awesome, thank you so very much. You seem to be, you also mentioned about respecting other nations' points of view, right? And that reminds me of early on, Constantine, you mentioned early on about human rights and one country, the basic human rights should be the same from one to another. They may differ in some other aspects, but then this is exactly where we lawyers come in. We should provide a bridge between two nations, right? To remove all the differences, to alleviate all the misunderstanding which may cause more serious disputes. So would you like to develop a bit more on this, Constantine?
Thank you for the question. I think the human rights, they not should be common. They are common. And the problem now is that, like previous years in Russia, we thought that the chaotic legislation which we have, it's a problem of our parliamentarism. It's only a Russian symptom. And now, when I look what's happening in the world, I think this type of chaotic legislation, it's like a sign of legal disease, like whole world, because each country trying to find their own recipe. I mean, legislation recipe. I think it's a big threat. So I'll try to speak again about the bridge. What do I mean when I'm speaking about to build a bridge? To build a bridge is to build our own expertise. If we create this expertise in new reality, I mean new type of law, so we can handle our client, we could take a hand and help them to cross this bridge. That's the second and main point for me.
Yes, I think so. Yeah, I think we have to grow ourselves. We have to study to see how global economy shapes politics and how politics shapes our national law, right? And I think there's a lot for us to learn. But I'm going back to point about Lawson mentioned about the importance of adopting mediation, arbitration, but it's actually the mainstream dispute resolution nowadays, right, to settle cross-border trade disputes. But Jerome, funny enough, we mentioned the submarine transaction, right? Could that transaction ever been able to be settled between France and Australia by mediation, for example? I think you have to unmute, Jerome. Sorry, you may have to unmute.
Sorry.
Yes, okay.
There we go. Sorry about that. One of the things we find in mediation is that an apology will go a long way in a dispute when there has been a misstep. And I was fascinated to see that when President Biden met with President Macron, he apologized. He said, we could have handled that better. And Macron seemed to be quite moved by that open admission of a misstep. And we see that in mediation. And that's a great example of of the benefit of trying to see the position from the other side. Obviously, someone on the United States said, hey, look, France felt like it was undermined and that something happened behind its back. And we should acknowledge that. It happened. And that will go a long way. And we see that in mediation all the time in terms of it's taking a really, long step to getting the parties to a resolution. So I think it's a wonderful example of, I don't know if they did mediate, but I think a mediation would have been a wonderful and very effective tool in that dispute.
Will you go for Albert in this case like that? Do you think Scott Morrison should have asked a lawyer to speak to France on their behalf first before talking to them directly? Using your suggestion is to always follow with the law, legal profession should go first.
Based on my experience and knowledge in legal profession, some points, sometimes they told now I already noted that the mediation arbitration, these are nowadays. It is better than we file the case in the ICC, because if we can make mediation in any top matters, each party can be touch hand longer and can make friendly for future good relations. And then now we are speaking based on the troubled water. Why troubled waters? Because of based on natural resources. Without natural resources, this area will never trouble waters again. So that how to divide, how to share, how to cooperate, and who is the power? We don't say based on the power. We have to be based on international relationship. And now the IPE model, ISS model will be very good cooperation these among countries.
Right, thank you. Yeah, you have already mentioned this point before, Mr. Sami. Absolutely correct. As I say, it's about time we should say that. Well, normally when we talk to your opponent, say, it's all right. The matter is already in the hands of my lawyer. That always sounds very not very friendly. That's always suggested the next step will be litigation. But things may have changed now. I'll leave the things to the lawyers to represent the interests of a country or a company to negotiate with the others, not necessarily to mount any litigious action, right? That must be something we lawyers can do and we should do. Now, this is the time. We only have about 5, 6, 7 minutes. I would like to invite some of our audience here in this room and also those online. If they have any questions, please raise the question, and or you would like use on the stage your views as well. Anyone want to ask a question or say something? From the floor here first. And any questions from the online question we have received yet? Yes, Mr. Kan. Mr. Fred Kan is a leading lawyer in Hong Kong and has a lot of experience in international relations as well. Mr. Kan.
Well, very nice to see you, Jerome. Haven't seen you for a long, long time. I think it's the most interesting dialogue between the 4 speakers, and I think they have covered a lot on inclusion and cooperation. I think what the world needs is more understanding, and I think all the speakers have demonstrated that the lawyers, the legal profession, can be the bridge. Thank you.
Yes, that's right. I'm sure we all agree here, Jerome. Jerome, I always try to learn to pronounce UIA in French properly, but I really don't want to torment your ears.
Don't bother.
Yeah.
But I do want to take the opportunity to say hello to my friend Fred Kahn, who has been a wonderful member of UIA and and
Yes.
really helped us develop good relationships. So thank you.
Good. Yes, and the pandemic really making traveling impossible, almost impossible. It's so difficult. Otherwise, I just want to know that it was. I was the president in '09, I think, right? Yeah, wow. I came over to Florence, I think the UIA conference, something like that. Anyway,
Oh, that was a good one.
yeah, that was a good one. Yeah, we missed all these international exchange of views. This legal fraternity we need to see. We can't see enough of each other and exchange our views. This is one world where the lawyers should stick together. Together we can change the world. I think I met you, Albert, right? Well, I think I came over to Miami about I forgot 1-4, 1-5. You show me around, yeah. I came to your old law society premises, I think. Yeah.
Right.
Yes, I remember that. Yeah. Thank you so very much. And of course, I know Lawson very well. I'm not sure I have met Mr. Constantine, but then, well, never too late. And we come to Moscow every now and then. Now, everyone, this is a very convenient time to bring this session to a close. And we do have some takeaways, right? Very important takeaways. Of the 4 distinguished speakers, they have given us very insightful analysis of the situation, that is to say, the importance of bridging between different nations. First of all, you talk about human rights issue, you talk about the rule of law. They're all the same, and they should be equally applied with whatever language you may use. But then there are differences between nations, and we do need someone to play the role as a bridge, to bridge over the differences and bring harmony. And this is the theme of today, and this is the job of we, the lawyers, should do. And we learned something very important from Mr. Roth, is that always try to understand the issue from the perspective of your opponent. Do not think about it as always from your point of view. Learn to respect other people's point of view. That's something we should learn. And of course, Somin had reminded us that there are a lot of international disputes who have been settled by embarking on bilateral agreements like IPE, ISS. ISS has been very successful, International Social Security. And of course, we want to thank Lawson of just sharing with us the importance of compliance, and this is the duty we owe to our clients, and how compliance are actually the roots of, well, the compliance is the root of competition. Compliance is the root of productivity. The compliance is also life. Well, to me, compliance could be bread and butter for lawyers, legal work as well, of course. Right. Okay, then. Now, on that note, unless you have anything you want to discuss, I will close this session. And before I do that, I invite you to join me to thank all the 4 distinguished speakers. Thank you very much. I'll hang it back to our MC.
So thank you, our panel chair, Mr. Hyun Wong, as well as distinguished panelist speakers, Mr. Konstantin Dobrinin, Mr. Jerome Roth, and Mr. Albert Zollman. So before this session formally ends, may I invite our distinguished panel speakers for a photo. So for Mr. Wong, who is on site, may I invite you to look at the camera at the back, the one at the back, the black one. And then for those on the web, may I invite all of you to look at the camera in front of you and then be prepared. Okay, on a count of 3. Okay, say 3, 2, 1, look at the camera and smile. Okay, do that again. Do we need? Okay, good enough? Okay, excellent. Okay, so thank you.
Yeah, thank you very much for the insight. And we learned a lot from different views from different speakers. And may we escort Mr. Hyun Wong off the stage? Yeah. I'm waiting. Take your time. The discussion on session 2 ends here. We will now take a 15 minutes break before we should begin for session 3. Again, there's no need for the online participant to log out of the sessions. See you again in a minute.
Welcome to Session 3, Building Harmony in Diversity through Strengthening Effectiveness of Dispute Resolution Mechanisms Applicable in the BRI Jurisdictions. Diversity, inclusion, openness, and building win-win partnerships are synonymous with the Belt and Road Initiative. With over $9 trillion in trade across 140 Belt and Road Initiative partner countries and regions, how best can lawyers resolve disputes when they arise so that we can focus on building and sharing prosperity? Let us hear from our eminent speakers their points of views on the topic, which carries growing significance in the legal industry.
May I introduce the panel chair of this session, Ms. Vanessa Pan, BBS, MH, JP, our immediate past president of the Law Society of Hong Kong, and the president-elect of Law Asia, Ms. Pan.
Good afternoon. Welcome to session 3 of the 4th Belt and Road Conference. Under the BRI, it's very important to build harmony in diversity. So this session will look into a very important issue. How do we strengthen the effectiveness of dispute resolution mechanism along the Belt and Road? I have the honor to introduce to you our 4 distinguished panel speakers. First is Dr. James Ding. Dr. Ding is the Commissioner of Inclusive Dispute Avoidance and Resolution Office, Department of Justice of the Hong Kong SAR of the People's Republic of China. His office was set up to better cope with the challenges and to seize opportunities offered by the BRI and the Guangdong, Hong Kong, Macau Greater Bay Area Plan. Dr. Ding coordinates and promotes various policy initiatives for dispute avoidance and resolution, as well as on advancing the rule of law. He has published on different subjects of international law and international cooperation. In a short while, I would like to pick Dr. Ding's wisdom on how online dispute resolution can benefit businesses, particularly for micro, small, and medium enterprises along the Belt and Road, leveraging the APEC collaborative framework on online dispute resolution. There is recently launched platform called Inclusive Global Legal Innovation Platform on online dispute resolution. I believe we are all very interested to know more about this platform. Also, on our panel today is Mr. Prashant Kumar. President Kumar is an economist turned lawyer. He is currently the president of the Bar Association of India and has been a past president of Law Asia. He is the convener of India Committee and founder member of BRICS Legal Forum, and a member of the Board of Directors of International Legal Assistance Consortium, Stockholm. President Kumar has the wealth of experience in international and domestic arbitrations and has engaged in missions relating to various major incidents in different parts of the regions. Currently, President Kumar is intensely involved in the project to establish dispute resolution institutions network for the emerging economies and BRICS. We will be looking forward to hearing from Mr. Kumar about his valuable experience and tips on setting up mechanisms to facilitate dispute resolution, especially at the international level. Another distinguished panelist is Ms. Pui K. Emmanuel Ta. Ms. Ta is the CEO of EBRAM International Online Dispute Resolution Center Limited. With over 15 years of experience in international arbitration and case management, Ms. Ta has supervised hundreds of international arbitration cases in a wide range of jurisdiction and economic sectors. EBRAM, which Ms. Ta leads, is a pioneer local NGO that provides one-stop, speedy, and cost-effective online dispute resolution and law tax services to help SMEs and enterprises on cross-border deal-making, dispute avoidance, and dispute resolution. We will be looking forward to hear from Ms. Ta about how EBRAM has accomplished its mission so far, including a scheme that helps to resolve COVID-related disputes and other EBRAM initiatives. Last but not the least, Professor Jiao Yun, who has also with us on this panel. Professor Jiao is Henry Chang Professor in International Law and Head of the Department of Law at the University of Hong Kong. He is currently the representative of Regional Office for Asia and the Pacific of the Hague Convention on Private International Law. He is listed as arbitrator in a number of international arbitration commissions. He is also a prolific writer. He has published widely on various topics, including dispute resolution and space law. I am sure we are all delighted to hear from Professor Jiao about the different platforms and channels for BRI dispute resolution. And from the perspective of a law scholar, his visionary view on how we can strengthen the dispute resolution mechanisms. Now we shall hear the presentation by the four panelists. The first one will ask Dr. James Ding to give us his presentation. Thank you, Dr. Ding.
Thank you, Melissa, and thank you for the Law Society for inviting me to this very important conference for the Belt and Road and for presenting at these panel sessions. In this panel session, we'll mention and discuss about effective dispute resolution mechanisms. And also in this morning sessions, we also mentioned about the tech, the law tech, for lawyers and for dispute resolutions. So I would like to introduce to you the use of law tech for dispute resolutions, and online dispute resolutions, ODR, is a typical examples. ODR is a inclusive, efficient, and effective means of dispute resolutions, and which has also gained international recognitions. I will briefly mention about some international development. First, what's ODR? According to the 2016 UNCITRAL Technical Notes on ODR, is a mechanism for resolving disputes through the use of electronic communications and other information and communications technology. UNCITRAL adopted the Technical Notes on ODR in 2016, and the United Nations General Assembly also recognized that ODR can assist the parties in resolving disputes in a simple, fast, flexible, and secure manner, without the need for physical presence at the meeting or hearing, and requested all member states to support the promotion and use of the technical notes on ODR. Why there is a need for ODR? The rise of the digital economy has driven significant growth in cross-border commerce, in particular e-commerce. But the traditional process of dispute resolutions for cross-border transactions are often too long, too costly, and with uncertainties about enforcement, in particular for litigations. This particulars, so for micro, small, and medium-sized enterprises, MSMEs, these MSMEs have low legal departments, no dispute management teams, and often is a very small firm that lack resources to deal with cross-border litigations or cross-border disputes resolutions. The outbreak of the pandemic has also caused significant disruptions to the international supply chain, and we can see a rising number of local and cross-border disputes. And when face-to-face dispute resolutions has been rendered ineffective under the pandemic because of the lockdown or the prohibition of gathering, there is a pressing need for MSMEs to resolve disputes in a time-efficient and cost-effective manner. Therefore, ODR provides a viable option, in particular for MSMEs, to resolve cross-border disputes in a speedy, efficient, and cost-effective manner, which may also encourage them to go global in their transactions. There are many significant advantages of ODR for businesses along the Belt and Road. First, it can overcome geographical and language barriers. Since ODR can be conducted online, people do not need to travel and will not be bound by their geographical locations. And also some ODR providers may provide some additional features such as interpretations, translations that could help to overcome the language barriers. ODR is an efficient and cost-effective means to resolve disputes. Typically, the use of mediation arbitrations for ODR, as well as negotiations, can help to reduce the cost and also the time for dispute resolutions. And there's also no need to travel, saving a lot of travel costs as well. ODR is conducted in a secure platform, and using the technologies such as AI, blockchain, cloud, etc., it can assist parties in resolving disputes with high level of security. Therefore, it's a very attractive mechanism for resolving disputes, in particular for MSMEs. Given the advantages of ODR and the international recognitions, as I just mentioned about the UN General Assembly, ODR is gaining more and more attention worldwide and also in this region. I would like to briefly introduce the latest developments on ODR under the Asia Pacific Economic Forum, APEC. In APEC, the Economic Committee of APEC adopted in 2019 an APEC collaborative framework on ODR. The reasons why APEC has paid particular attention to the use of ODR as a means of dispute resolutions, because there's a survey showing that over 97% of the businesses in APEC economies are MSMEs. And a survey also showed that one of the major difficulties faced by the MSMEs is dispute resolutions, in particular cross-border dispute resolutions. For many of these MSMEs, the traditional means of dispute resolution is not really workable for them. They cannot afford cross-border litigations or cross-border arbitrations. The travel costs, the legal costs are simply prohibitive for them. So for many of these MSMEs, they just walk away with their loss, or some of them would not engage in cross-border transactions. There is a survey or a study in Japan asking the MSMEs there. Most of them do not want to go overseas for their transactions, and dispute resolution is one of the factors why they do not want to do cross-border transactions. Therefore, APEC has paid particular attention to this matter and promote the use of ODR. The APEC ODR framework, the scope is, at this stage, at the pilot implementation stage, is limited to business-to-business disputes, cross-border business-to-business disputes for low-value transactions. Let me briefly tell you why it's, at least at this stage, it's limited to business-to-business. Because after some discussions, people find out that consumer protection law in different jurisdictions are very diverse. So if it covers transactions, consumer transactions, that will be very difficult, at least at the initial stage. Therefore, the consensus is to limit it to business transactions at the current stage. And the survey also shows that the B2B transactions, in particular in e-commerce context, is much, much larger than business-to-consumer transaction. Therefore, APEC economies find that it's very useful to start with the business-to-business ODR mechanism. The APEC also developed the model procedural rules for ODR, which is a set of rules for resolving disputes in cross-border transactions in B2B context through the use of electronic communications and other information and communication technology. We also draw reference to the UNCITRAL technical notes on ODR in developing the rules. And the participating APEC ODR providers operating under the APEC ODR framework will have to agree to the use of the model procedural rules. And the framework is not intended to interfere with the operations of participating economies of their own ADR systems. And the key features of the ODR mechanism under APEC is a three-tier approach. It started with negotiations, followed by mediations, and ultimately by arbitrations. There is also a survey showing that in many of these ODR dispute resolution cases, most disputes will have been resolved in the negotiations or mediation stage. Only a few % will go to the arbitration stage, especially for these low-value disputes. We are at the stage of implementing the APEC ODR framework. The APEC Economic Committee will maintain a list on the Economic Committee webpage of ODR providers from participating economies that have agreed to the use of the ODR procedural rules and also to comply with the APEC ODR framework. So we are now encouraging ODR providers from participating economies to partner with APEC to provide the ODR services for MSMEs. The providers will need to submit a written undertaking of its commitments in this regard. And the ODR providers will also provide its own ODR platform for the resolution of these disputes. And APEC economies would encourage their businesses, especially MSME, to consider using ODR service provider listed under the Economic Committee webpage. APEC economies would also support the development and recognition of private international law instruments relevant to ODR. For example, the recently concluded mediation conventions by the UN, and the APEC economies may also enter into bilateral agreements to enforce the arbitral awards as necessary. The benefit of the ODR framework under APEC is, of course, include those ODR benefits I just mentioned at the beginning. And in gist, it provides speedy and cost-effective resolution of disputes between and among the MSMEs in cross-border transactions, which can build their confidence to enter into cross-border transactions. It also provides capacity for economic growth and development by APEC economies. So far, 5 APEC economies have opted into the framework. They are China, Singapore, USA, Japan, and Hong Kong, China. And more economies are actively considering to opt into the framework. A number of ODL providers have already indicated their interest to partner with APEC in providing the ODL services. I will also mention that under this framework, APEC will not develop its own platform, but it will partner with ODL service providers in different economies, in the economies that have opted into the framework. And EBAM is also one of the ODL service providers which has indicated the interest. EBAM will be speaking later on this panel. Lastly, I will mention just very briefly about the IKIP on ODL, the Inclusive Global Legal Innovation Platform on Online Dispute Resolution that has been mentioned by our Secretary for Justice this morning at the opening. While there are many benefits of ODL and we encourage its use, we also recognize that there may be some issues on ODL, in particular the international development of ODL, the standard that will require further study. Therefore, we have launched the IKIP on ODL in collaboration with UNCITRAL. The key objective is to study and to keep track of the relevant international developments and also to work out possible international instruments to tackle with these challenges and issues in collaboration with UNCITRAL. Under this platform, we have about 30 experts from around the group. We have experts from every continent except Antarctica. So it's a very representative group of experts who will share their expertise and also provide us very useful ideas and suggestions. We have our first meeting in March this year, and we are planning to have another meeting later this month. That concludes my presentations. Thank you very much.
Thank you, Dr. Ding, for his insightful sharing on the online dispute resolution. This is surely the trend that many will adopt, and this can give a lot of help to MSME in their resolving their cross-border disputes. And now we have our next speaker, President Prashant Kumar, who's the president of India Bar Association of India. He will join us online, and he'll give us some insight on how to set up mechanism to facilitate dispute resolution, especially in the international level. Thank you.
Thank you, Melissa, and thank you, Law Society of Hong Kong, for inviting me to this very important event. And I'm joining online, which itself shows that today technology is a big enabler. We just had a wonderful presentation by Dr. James Ding and speaking about ODR. And I also greet all of you on the occasion of Indian Festival of Diwali, which we are celebrating today. It's a holiday here, but I could not refuse the command of my dear friend and my next president of Lower Asia, Melissa. So I'm joining today, and it's a real pleasure. Friends, first a disclaimer. India is not formally a part of Belt and Road Initiative, but India is part of BRICS and BRICS Bank. And BRICS, which is Brazil, Russia, China, India, and South Africa, represents 5 big emerging economies globally, straddling into 4 continents, having different legal systems. And BRICS Bank and BRICS have signed MOUs to promote Belt and Road. So that is where I will present that what is the initiative in terms of dispute resolution that we are structuring in BRICS. So while I find it commendable that ODR is being promoted within the framework of APEC, and also EBRAM. Later on, Mr. Manuel will make a presentation on that, and it is particularly suited for small claims, for medium SMEs and small disputes. It is particularly useful because the otherwise cost-benefit ratio of the traditional dispute resolution, which is carried out physically in a neutral jurisdiction, does not justify, and so many disputes remain unresolved due to that. But still ODR cannot be answer to certain other challenges which we are facing and we are trying to find answers to while structuring the dispute resolution network for BRICS and emerging economies. And that becomes more contextualized when we talk about Belt and Road. So as far as those countries and economies which have advanced legal systems and which share common language, even if they fall between the civil law and common law jurisdictions, there may be differences in the legal system to that extent. But the dispute resolution community and institutions are sophisticated enough to take care of that. Where the real challenges come from are those economies, and especially when we talk about Belt and Road, where massive investment is being provided, is contemplated to be provided under the Belt and Road Initiative. There, the challenges are, and that the infrastructure to be built at a very high scale with huge investment, because such infrastructure could not be built previously. One of the prime reasons for that was the investment, so-called, from international standards, from multilateral institutional standards, the assessment of investability or having the stable political and legal system in so many of jurisdictions to attract foreign investment, to attract financial investment, because each investment is to be secured, the projects are to be implemented, and there has to be a strong legal framework to resolve disputes. So what is to be done there? Can the systems which are being developed for the economies where professions and the institutions are already at a stage where there is a maturity, there is a, professionals available, local law firms are there, local lawyers are there, who can help resolve disputes, draft agreements, and make the investments and projects go on smoothly while resolving disputes on the side. The answer is much more difficult for these emerging jurisdictions where language is an issue. The critical mass of trained legal profession which knows international ways of dispute resolution, is conversant with those matters, and is capable of doing that, is still in the works. So the challenge which we are trying to find answers to and building mechanisms for is not merely to have an institution which works on the broad principles of model law established by UNCITRAL. That is, of course, there is required to be followed, but the activities alongside it, how to build capacities, how to bring more common ground and understanding, and how to build neutrality within the, here I will say Belt and Road, but broadly I will say emerging economies framework. Because ultimately, international dispute resolution, one of the prime values which one looks for is an institution of credibility, and also which can provide neutrality so that there is lack of bias. So there have been many initiatives within China. Hong Kong International Arbitration Center and other institutions are there, and the APEC initiative is there. But still, I think there is a further need to build neutrality within the system of framework of emerging economies, so that the functioning is in a way where disputes are resolved with the understanding of the local laws, local situation, local ground realities, and not just on broad legal principles of dispute resolution. Because that is where, on the ground, I find there is a big dissatisfaction. When you apply broad legal principles which are internationally acceptable, you end up resolving dispute more on the basis of legal principles rather than going on the facts and understanding the local laws, which becomes sort of evidence in that dispute. And then there is a lack of appreciation of it, and also lack of experts in those local laws and jurisdictions to work with the arbitration panel to help resolve the dispute. So that is where the things fall apart. The required level of satisfaction is not there. So according to me, the real challenge lies in being an enabler, providing investment to the regions, to the countries which have not been found investment worthy because of the weak legal systems, weak enforcement of contract. So how to bring them within the realm of international dispute resolution, which is cost effective, which is efficient, and which takes into account the local laws, local regulations, local ground realities. Because all these projects are infrastructure projects, they are going to be implemented over a period of years and decades. There are some initial disputes, there can be ongoing disputes, and unless until we find mechanisms, institutions, and effective ways to resolve them, all these investments can become very risky, and all these investments and business decisions become fraught because of lack of effective dispute resolution. So I think it is not an initiative which can be done just at the end of one institution like BRICS. It requires larger collaborations, it requires larger understanding, and that's why the way we are trying to set up it in BRICS is to form a network where we share resources, where we share our expertise, and where also we will try to mount the initiatives to build capacity in the local professions, where the recipient countries of investments, where all these projects are to be implemented, are enabled, empowered in terms of becoming valuable partners and having a real stake in dispute resolution. So that is broadly I look at it. We have been working at BRICS level for past 3 to 4 years. Pandemic has, of course, slowed down some of the initiatives, but I think in a couple of years we will be up with functioning institutions with a broad framework. China already at the Shanghai Center. South Africa has roped in the existing China-Africa Center, which is at Johannesburg. And Russia, I had a meeting last month, is setting up a center. Similarly, Brazil is at an advanced stage. But the real value will be brought forth by bringing into the network more such centers in emerging economies, in Belt and Road countries, and then try to have common set of rules, some basic ground understanding and mechanisms to build capacity, to build trust and real practical, efficient, low-cost mechanisms for dispute resolution, not just for MSMEs, but for big infrastructure projects. Thank you.
Thank you, President Prashant Kumar. I think I really share your view because of the diversity, both in terms of cultural background, social, economic, of all the countries, jurisdiction along the Belt and Road. There's a need for collaboration, there's a need for more understanding. I think maybe later on in the Q&A session, I look forward to hear more like case study from President Kumar. Now we move on to our first speaker, which is Ms. Pui Kay Emmanuel Ta, who is the CEO of EBRAM International Online Dispute Resolution Center. Ms. Ta, the time is yours.
Thank you, Melissa. The Belt and Road Initiative is one of the largest infrastructure and investment projects covering 140 countries. Despite huge investment opportunities, we see physical borders and linguistic barriers imposing limitations on the effective resolution of cross-border disputes. Dr. James Dean spoke about ODR in his presentation and the significance of ODR to businesses along the Belt and Road in resolving disputes effectively. Today, I am going to introduce the ODR platform developed by EBRAM International Online Dispute Resolution Center, a platform that may be used to resolve Belt and Road related disputes in a fast, convenient, cost-effective, and secure manner. Before I walk you through the key features of our ODR platform, let me briefly introduce EBRAM and the law tech services that EBRAM provides. EBRAM is a non-profit company established in 2018 with the support of the Asian Academy of International Law, the Hong Kong Bar Association, and the Law Society of Hong Kong. EBRAM's vision is to provide a one-stop shop platform for commercial parties from all over the world by providing a deal-making, mediation, arbitration online platform integrating latest technology. EBRAM has developed its own video conferencing and e-signing systems and provides technical supports for hearing and law-related events. EBRAM not only develops ODR platforms and provides ODR services, but it also administers cases like any other arbitral institutions to ensure that the ODR process is conducted in accordance with EBRAM's rules. EBRAM has launched various sets of rules which provide a structure framework to ensure transparency, efficiency, and fairness in the ODR process. Now let me give you an overview of the ODR platforms developed by EBRAM. In June 2020, EBRAM launched the COVID-19 ODR platform, following the introduction by the Hong Kong government of the COVID-19 ODR scheme, to provide a speedy and cost-effective means for the general public and businesses in Hong Kong to resolve COVID-19 related low-value disputes. Under the scheme, the platform is applicable to disputes arising out of or in relation to COVID-19, cases where the claim amount is less than 500,000 Hong Kong dollars, and cases where one of the parties to the dispute is a Hong Kong resident or a Hong Kong company. The platform takes the form of an interactive website with video conferencing technology. The platform is available in simplified and traditional Chinese, as well as English, and adopts a three-stage proceeding: negotiation, mediation, and arbitration. Each stage of the proceedings will be completed within a short period of time. The COVID-19 ODR proceedings are governed by EBRAM's COVID-19 ODR rules. Under this scheme, EBRAM has trained more than 150 mediators and arbitrators. They came from diverse backgrounds and different jurisdictions, including Hong Kong, the United Kingdom, Australia, India, and Singapore. Now turning to the ODR platform under the APEC framework. EBRAM is an ODR provider under the APEC Collaborative Framework for ODR, and its role is to assist enterprises, in particular MSMEs in the APEC economies, to resolve cross-border business-to-business disputes speedily and cost-effectively by providing a reliable and secure platform. Our ODR platform is available for disputes under 500,000 Hong Kong dollars. However, parties may use EBRAM's ODR rules under the APEC framework to resolve disputes of more than 500,000 Hong Kong dollars. EBRAM has launched its APEC ODR rules, which comply with the APEC Collaborative Framework for ODR and incorporate the APEC Model Procedural Rules. EBRAM is currently developing its APEC ODR platform, which will commence operation towards the end of the year. The platform will adopt a multi-tiered ODR process with a three-stage proceeding: negotiation, mediation, and arbitration. EBRAM's APEC ODR rules allow parties to exercise their choice over many aspects of procedure and as to the manner in which they would like to conduct the proceedings. For instance, in the context of the APEC ODR process, parties may agree to extend the time limit of the negotiation or mediation phase, or even return to mediation after the commencement of the arbitration stage. ODR, and in particular EBRAM's APEC ODR platform, may present opportunities for the resolution of BRI-related disputes. The APEC ODR framework indeed covers several Belt and Road jurisdictions who can benefit from EBRAM's APEC ODR rules to resolve cross-border disputes through a safe, convenient, and cost-effective ODR platform. Let me now walk you through some of the main features of our ODR platform. EBRAM's platform provides parties and neutrals with a convenient, efficient, and secure communication channel for each stage of the proceedings. So from the filing of the notice to commence proceedings up to the settlement agreement or the rendering of an arbitral award, parties and neutral will be required to exchange all communications and case submissions through the online platform. The platform contains functions such as a video conferencing system, a calendar for relevant dates and deadlines, and a board for the neutral to communicate practical information with the parties. Meetings, case management conferences, and hearings can be arranged through the platform, and video conferencing is available throughout the process to maximize efficiency and to reduce cost. In terms of technology, the platform will include real-time transcription, e-bundle, and e-signature. The platform is currently available in Chinese and English, and will also be made available in other languages. As you can see, strong technical support in all aspects will be provided to users of the EBRAM's ODR platform. In addition to this, EBRAM will issue a note to provide guidance to parties and neutral on the conduct of the proceedings under its rules and on the use of its ODR platform. Now, why choose EBRAM as your ODR service provider? Using ODR to resolve disputes takes significantly less time than litigation and involves much lower cost. In terms of efficiency, all files are organized and searchable and can be found in one place. The platform is accessible on desktop, mobile, or tablet. The platform will provide a cost calculator that allows the parties to estimate the likely cost of a proceeding according to EBRAM's schedule of fees attached to its rules. The cost calculator will generate the amounts for EBRAM's administrative fees and for the neutral's fees. Now, in terms of security, it is a reliable and secure platform. In terms of who may access the platform includes an authentication system to verify the identity of any party who registers on the platform. All documents exchanged through the platform will be saved on the highly secured cloud storage using blockchain technology. EBRAM's platform is also covered by the Hong Kong Personal Data Privacy Ordinance. More importantly, any neutral will be appointed by EBRAM to conduct the proceedings in the event that the parties are unable to agree on one. EBRAM will choose a suitable candidate from its panel of neutrals. EBRAM's panel comprises experienced mediators and experienced international arbitrators coming from different jurisdictions. In addition to the COVID-19 and the APEC platforms, EBRAM is currently developing a standalone e-mediation and e-arbitration platform to provide ODR services at a reasonable fee without restrictions in terms of the location where the dispute has arisen, the nationality of the disputing parties, the type of dispute, or the amount in dispute. In June 2021, EBRAM launched its mediation rules and arbitration rules. Copies of these rules can be found on EBRAM's website. Parties can opt for an online negotiation, e-mediation, or e-arbitration, or a combination of all three modes. EBRAM's e-mediation can help parties reach a settlement. Through the e-mediation platform, parties can exchange documents and conduct their mediation sessions with the mediator remotely by video conference. EBRAM's e-arbitration is a neutral way to resolve disputes effectively and deliver awards that are enforceable in all Belt and Road jurisdictions. E-arbitration can be defined as an arbitration process in which all aspects of the proceedings are conducted online using a secure platform. Parties will be required to exchange all submissions and communications with the arbitral tribunal through the platform. And a final binding and enforceable award rendered by the arbitrators will also be notified by EBRAM to the parties via the platform. Parties to an online arbitration administered by EBRAM and conducted under EBRAM's arbitration rules can also apply to the PRC courts for interim relief against mainland-based counterparties under the Arrangement on Interim Measures between the mainland and Hong Kong. EBRAM is one of the 6 institutions qualified under this arrangement. EBRAM has been working on other projects to enrich its law tech services. First, the development of an AI machine learning translation, e-transcription, and e-bundling systems, which will be new features to add to the existing and future platforms. And second, the development of EBRAM's Legal Cloud portal to provide safe and affordable data storage services. EBRAM will adopt advanced technologies such as blockchain, real-time translation to provide a deal-making platform. Through the deal-making platform, businesses from the Belt and Road countries can efficiently and safely negotiate a deal by conducting meetings and sharing documents and conclude their agreement digitally. Advanced technologies are going to transform the dispute resolution landscape. AI can create significant time and cost savings for dispute resolution. Applications may include chatbot, AI translation, or e-transcription. The adoption of blockchain will lead to a significant shift in the way contracts are managed and parties interact with each other. It tracks down and records contractual events and generates a robust and reliable audit trail of past events, if and when a dispute arises. This will help narrow down the scope of disputes or avoid disputes and improve the efficiency of the dispute resolution process. The development of cloud services can provide highly secured storage for legal documents and materials with advanced cybersecurity technologies, including certificates, biometric, or token-based authentications. EBRAM is a forerunner in law tech and strives to be a key enabler for cross-border trade under the new normal through its services such as e-signing, ODR platform, as well as other law tech services. EBRAM will continue to integrate the latest technology into its platform and systems. Our APEC ODR platform will be launched by the end of December, and the standalone mediation and arbitration platform in the second quarter of 2022. Let me conclude by saying, as a provider of online dispute resolution tools and services, and with its arbitration and mediation rules, EBRAM's ODR platform provides a particularly appropriate avenue for resolving disputes arising out of the Belt and Road projects in an effective and harmonious way. Thank you.
Thank you, Ms. Carr. I'm actually very excited to hear what you have presented. I'm proud of what eBrand has done in the past few years. You really have done a lot. And we can see eBrand has really embraced the ABC in technology, A for artificial intelligence, B for blockchain, and C for cloud. I think, sure, in the coming years, there's a lot of new initiatives will be in place. We look forward to hear more about that. Thank you, Ms. Ta. Our next speaker is Professor Zhao Yun. Let me just let Professor Zhao to have his time. He has a lot to share with us. Thank you.
Thank you, Chair. Good afternoon, ladies and gentlemen. It gives me a great pleasure to be here to speak on the Belt and Road legal issues. I think Belt and Road is nothing new to all of you. I think we have heard the term many times. It is a global development strategy initiated by the Chinese government in 2013, involving infrastructure development and investments with countries and international organizations across Asia, Europe, Africa, the Middle East, and the Americas. It aims to build connectivity and cooperation between China, the land-based Silk Road economic belt, and the 21st century maritime Silk Road. Trade along the BRI countries continue to increase despite the ongoing COVID-19 pandemic. However, the BRI projects provide new opportunities as well as legal risks. Over 60 countries actually situated along the Belt and Road with legal system covering common law, civil law, Islamic law system, or hybrid legal systems. The level of legal development and enforcement also varies to the great extent, which requires coordination among the countries, diversity, inclusion, openness, and building win-win partnering as a synonym with the BRI. Dispute resolution proves to be a major issue that will need to be seriously looked into. The primary objective of the BRI is to create a cohesive economic area by building both hard and soft infrastructure in a BRI community with predictable rules and enforceable legislation. With the challenges identified above, it is of utmost importance that legal conference for a common legal structure for both dispute resolution and enforcing agreements between and among BRI countries. Legal convergence or legal conversion is indispensable to increase predictability of trade and investment activities in area and to forge confidence of relevant entities. In this regard, bilateral investment treaties and bilateral regional free trade agreements are important mechanisms to realize legal convergence. Indeed, as I have just mentioned, China has reached many trade and investment agreements since the announcement of the BRI in 2013. The existence of these agreements lay a solid foundation for trade and investment within the area. Another important aspect is the use of various dispute resolution mechanisms. It is inevitable trade and investment disputes will arise, will continue to come up. A viable legal framework for efficient and effective dispute resolution is of utmost importance. The BRI has always been touted as a project for cooperation under the paramount principle of extensive consultation, joint contribution, and shared benefits. In this spirit, all the BRI countries should try their best to settle disputes through dialogue, resolve differences through discussion, enhance cooperation and mutual trust, and reduce mutual misgivings. However, the differences in participating members' political, economic, and cultural environment means that disputes could be resolved through a variety of mechanisms, which may lead to different outcomes for the same type of disputes. Against this backdrop, several channels for resolving cross-border disputes between the BRI countries could be explored, including the WTO dispute settlement system, investor-state dispute settlement mechanism, domestic courts, and alternative dispute resolution mechanism. Now let me look into these different mechanisms one by one. The WTO dispute settlement mechanism still works for interstate trade disputes. However, the mechanism is increasingly facing serious challenges, including its time-consuming process, lack of transparency in decision-making, dangers to state sovereignty, the high costs, etc. More importantly, it does not work for the resolution of disputes between private parties. Investor-state dispute settlement mechanism is no doubt another important mechanism under various international investment agreements, seeking to protect foreign investors from unfair treatment in the host country. According to the UN Conference on Trade and Development, China has 107 BIT, bilateral investment agreements, treaties in force as of 2021, this year. However, China has yet to sign investment agreements with 12 of the countries along the Belt and Road, which means that Chinese investors and that their outbound investments may not be able to benefit from the ISDS mechanisms. Domestic litigation remains to be a viable way out for many disputes. However, litigation does not appear to be the best way out. In view of the time and the cost needed for litigation, issues such as applicable law, jurisdiction, recognition and enforcement of foreign judgment, etc. But we do see some new developments in the litigation field. The major development is the establishment of the China International Commercial Court in Shenzhen and Xi'an in 2018, with the main purpose to settle international commercial disputes under the Belt and Road Initiative. The International Commercial Court has its headquarters in Beijing and is to be supervised by the Supreme People's Court and is an integral part of the Supreme People's Court. Judges shall be familiar with international treaties and customs and practice of international trade and investment. If we look at the ICC, the China International Commercial Courts, we can witness several very important measures that have been put in, or we can say it's kind of an innovative mechanism that have been input. The first is one-step stop for diversified dispute resolution, incorporating ADRs into conventional litigation. In July 2021, a one-stop service for resolving international commercial disputes was launched by the Supreme People's Court to meet the new demands of the online era and provide fast, convenient, and low-cost legal services. For example, litigants can access the platform by visiting the website of the CICC via computer, or by using their mobile phones to access a mini program on WeChat, an instant messaging tool that is popular in China. I think WeChat has been used not only by the international commercial courts, but also many other internet courts in mainland China already. Domestic and foreign litigants can choose how they want to solve the disputes, whether through mediation, arbitration, or litigation. And the platform has both a Chinese and an English version. The platform which makes full use of technology-friendly smart courts, also offers other services like legal searches and ascertaining foreign laws. The second point, I think, is rather important to see the establishment of International Commercial Expert Committee in 2018, also the same year, which consists of experts and scholars from China and countries along the BRI route. The expert committee is argued as a kind of a signal for China to have the paradigm shift from the traditional emphasis on soft law rules in international legal order. Some scholars argue that a rising new Chinese economic legal order that is characterized by China's decentralized mode of trade governance through a pragmatic, incremental development policy grounded in soft law and norm-based networks. So we are not simply talking about soft law rules. We are not talking about the MOU. Of course, we can see quite a lot of MOUs were concluded for the Belt and Road initiatives for China. But at the same time, we can see the norms, the rules, the hard law increasingly takes up a more important role. The third, tailored litigation procedure. So we can see the rules has been modified to a certain extent, including the combination of consensual jurisdiction and discretionary jurisdiction. The evidence can be submitted in English language. Also, the dissenting opinion can be published in the final judgment, etc. So overall, it is expected that China's approach to BRI dispute resolution as represented by the one-stop diversified dispute resolution mechanism will continue strengthening its functions and more effectively meet the demand of parties to the BRI disputes. If the international commercial courts could continue to enhance its internationalization, further optimizing its working mechanisms while offering a more efficient, high-quality service for resolving international commercial disputes that enhance the judiciary's international competitiveness. It will play an essential role to provide harmonization of rules and mechanisms across BRI jurisdictions. Alternative dispute resolution, ADR, has been argued to be a viable way out. Arbitration is currently the most proactive and well-utilized method. Around 60 of the BRI participating members are contracting parties to the 1958 New York Convention, which facilitate enforcement of foreign arbitral awards. Hong Kong is aiming to become an international dispute resolution center. The Hong Kong IAC has extensive experience in resolving BRI disputes. And as Ms. Ta has also just mentioned, the e-brand will play an increasingly important role in this area. So Hong Kong, we can see, have also hosted various international organizations and also arbitration commissions around the world. In 2015, the Supreme People's Court issued an opinion on the People's Court providing judicial services and safeguards for the construction of the Belt and Road, which explicitly encourages the use of international commercial arbitration in resolving BRI disputes, and requires the People's Court to efficiently recognize and enforce BRI arbitral awards, and to improve the mutual recognition and enforcement of arbitral awards with BRI countries that are not yet members to the New York Convention. Apart from arbitration, mediation is taking up an increasingly important role, which is believed to fit in the Chinese culture, which emphasizes social harmony, which is, of course, the theme of our session and the conference. Mediation has also other advantages, such as efficient and effectiveness, maintaining commercial relationship, etc. The civil justice reform in Hong Kong emphasizes the use of mediation. The same goes to mainland China, which has a long history of mediation. The Supreme People's Court has released several important documents to promote the use of mediation and advocate the grand mediation scheme. Apart from people's mediation, which many of you are very familiar with. We also have judicial mediation, administrative mediation, and meet-up. China has also introduced commercial mediation 10 years back. The first international commercial mediation center was set up in Shanghai and has been providing very useful services already. Apart from what we have mentioned about evaluative mediation for the people's mediation and administrative mediation, we can also see the introduction of facilitative mediation in mainland China. A lot of training courses has been put in. But of course, I also noticed that we have some discussions about whether we do need to have a clear borderline between facilitative and evaluative mediation or not. The first commercial mediation center has already quite a lot heavy caseload. The adoption of the Singapore Mediation Convention could provide another impetus for the development of mediation along the Belt and Road region. Further, wide use of ODR is a trend, as James Dean and also Ms. Ta has already mentioned. If we look at the broad picture, some experimental projects came up in mid-1990s in the United States. The experiment was not very successful, was not very sustainable. All these projects actually survived only for 2 or 3 years. But after, in the late 1990s, we can see very successful model, that's a domain name dispute resolution, which was administered by the ICANN, Internet Corporation for Assigned Names and Numbers. The CTAC released its online arbitration rules in 2008, but was also not very successful at that time. So far, I think only 2 or 3 cases were blocked under the online arbitration rules. So there are quite a lot of discussions what we can do to further promote the ODR. And I believe that what we discussed today actually can really helpful for the further development of the ODR, including the EBRAM platform and also other platform that was developed in other jurisdictions along the Belt and Road route. The BRI offers ample opportunities for lawyers and law firms. Liberalization of legal services is one major area for consideration in the BRI area. In recent years, China's Ministry of Justice has taken steps to liberalize the legal industry, particularly with significant achievements in free trade zones. China made commitments to open the legal services market upon the WTO entry. Further developments was made when the CIPA was signed between the mainland China and Hong Kong, providing preferential treatment to Hong Kong service provider. Now with the Great Bay Initiative, we can expect to see more liberalization measures for the legal industry in the future. Last but not least, we should also note the importance of cultivating legal talents. Legal education is important to cultivate legal talents. It's good to see the establishment of alliances such as the New Silk Road Law School Alliance and also University Alliance for the Silk Road in 2015 to serve as cooperative education platform to further regional development. Annual conference was organized to facilitate exchange on legal education and legal training among the alliance member universities or law schools. As an international financial center and legal service hub in the Asia-Pacific region, Hong Kong is an important city along the maritime Silk Road in the BRI. Hong Kong has a mature legal system. We have an arbitration center, we have EBRAM, we have Hong Kong courts and other legal institutions. All can serve as a place for sound and fair dispute resolution venue. Hong Kong lawyers have their advantages in knowing both Chinese and Western laws and better understanding of the legal system of financing methods of Islamic countries. So the GBA offers excellent opportunities for Hong Kong. So no doubt the GBA should serve as the overall planning for the BRI. It will contribute to the theoretical and practical innovation path for how to solve international commercial disputes between different legal systems, as well as provide an international commercial dispute resolution mechanism for countries along the BRI. We have witnessed rapid developments in the past years since the announcement of the BRI. The Asian Infrastructure Investment Bank provides support for infrastructure building in the Asia-Pacific region. China has signed various bilateral and regional cooperative agreements with other BRI countries, which paves the ways for expansion in trade and investment. Dispute resolution has always been on the fast track, with an emphasis on the use of arbitration, the establishment of international commercial courts, and also the adoption of ODR. The BRI brings challenges as well as opportunities. Legal convergence is on the right track. It is important to keep up the momentum for continuous efforts towards a harmonized legal environment and culture within the community to later stage. The planned completion year of the BRI is 2049. I hope that all will be done before that. So I think we will have confidence to see that the role of BRI and FTA will play an even more important role. And also, of course, the current multi-jurisdictional dispute resolution system should be further enhanced. Last but not least, there is a need to cultivate more legal talents specialized in multi-jurisdictional legal services. So with this, I conclude my presentation. Thank you very much.
Thank you, Professor Jiao. I think he has made an excellent overview of all the channels and platforms of like dispute resolution. And I think today's discussion is very fruitful. We get to know each other, we get to learn more, there's experience sharing. And now we come to the Q&A session. Let's see, like, what question have we got? Interestingly, the first question or response I got is from Prashant Kumar. President Kumar mentioned about the fact that he's very interested about eBRAM. So I think eBRAM, Ms. Tar has made a great introduction about what eBRAM has done. And I think President Kumar is interested to know more. And also, of course, I'll put them in touch with each other. That is the beauty of having a platform like here in the Belt and Road Conference for all the speakers, all the participants to know each other, to get connected. That's about connectivity. I think I would like President Kumar to make a few comments about like what sort of insight you got after like hearing eBRAM, and how we can sort of like do more promotion about eBRAM and how people can benefit from it. Because like it's important for us to sort of learn from each other and how to perfect the platform. President Kumar, we would like to hear from you and share your experience.
Thank you, Melissa. First of all, when we are all talking about on the same, priority and the same objective, shared objectives, that we should be able to build frameworks, we should be able to build systems and institutions which are utilized by various stakeholders and various stages of legal sophistication and development, because that's how the universe of Belt and Road and the requirements of emerging economies are. So first off, first mindset to achieve that has to be to make an effort not to reinvent the wheel, not to make further investments, try to do things from the scratch, but learn from each other, try to leverage what is existing, try to modify it, get into collaborations. So when eBRAM has made significant progress already, and in BRICS we were working on the ODR system, and since India has a very good software development capacity, so the driver of it has been India. But, this requires investment. This requires, involving experts to build the system from the scratch. So I'll be very happy to learn more about eBRAM and see that how not just India, there can be a collaboration through BRICS. So we are going to have at the end of this month our steering committee meeting of BRICS. And if I learn more about eBRAM, I'll be very happy to introduce it to BRICS and see how the collaboration can work. That is number one. Number two, also when we say that one of the main objectives we are meeting here is to make dispute resolution more available, more universal, and less expensive, so that even SME disputes can be resolved through it. That is the objective. So how the cost can be reduced? Cost can be reduced by scale. If you have number of users and there is a platform which is already built, so then naturally that platform can bring in more cost efficiencies, reduce the cost, and have further investments to upgrade it. So this is the approach I think we should all have. And this is why Melissa rightly said that this kind of event is very useful for networking, from learning from each other, and also, if possible, to leverage and not to duplicate. Thank you.
Yeah, thank you, President Kumar. I think there's no need to reinvent the wheel. We can learn from each other, we can modify, and I think that's a lot we can do. And actually, before I will ask Ms. Tar to give some response, but also I add one question. Because I'm very interested when I look at the so-called work in progress about the AI machine translation. Because we're all understanding along the Belt and Road jurisdiction, people use different languages. And language barrier is actually one of the big problems. Yeah. Maybe Ms. Tai, I'll give the time to you.
Yeah. Thank you, Melissa.
Thank you so much.
Thank you, President Kumar, for your comments and invitation to discuss with us. We're more than happy at eBRAM to engage in discussions and collaborations with other institutions in finding ways to enhance the dispute resolution process and to reduce costs as well, as you mentioned. So we're more than happy to discuss with you and in my presentation I should have mentioned that you can learn more about eBRAM through our website. There was a QR code after my presentation, but I forgot to mention that. So you can just scan that QR code and have direct access to our website. And also the team, my team and myself, we are available by phone and email to respond to any queries that you may have. So I'm happy to share from you as well and to see how we can provide our law tech services to other institutions as well. Thank you very much.
I think I'll add all the participants online, if you're interested about eBRAM, go to their website and you can check out more. Otherwise, you can write to Law Society for Hong Kong. We'll try to get you connected. That's our role. Okay, now with Q&A, I do have a question for Dr. Ding. Hong Kong is one of the leading dispute resolution centers in Asia Pacific. And we are a preferred venue for resolution of commercial dispute. But how can this positioning of Hong Kong contribute to the access of justice in the Belt and Road jurisdictions? And also in line with advancing the long-term Goal 16 of the United Nations 2030 Sustainable Development Goals? Dr. Ding, thank you.
Thank you, Melissa, for these excellent questions. First of all, I would say that Hong Kong has a long and rich common law traditions underpinned by rule of law and independence of judiciaries. And we also have a mature legal systems, and our international ranking on rule of law and independence of judiciaries is very high every year. And as you said, we have a very high ranking in our dispute resolutions as well. we are ranked the third in the Queen's University survey, that we are the third most preferred seat of arbitrations. So I would say that making good use of our legal and dispute resolution services could be one of the possible way to contribute to the BRI and also for advancing access to justice. And I will also mention that last year the Department of Justice has launched the Vision 2030 for the rule of law, which aims to promote the rule of law and access to justice in this region and beyond. We can also contribute to the UN 2030 agenda. I must not forget to mention that we have a very good pool of talents in Hong Kong. We have over 12,000 lawyers in Hong Kong, over 1,500 foreign lawyers from 30 jurisdictions or more, and more than 80 foreign law firms in Hong Kong. So we have a very metropolitan and international pool of talents in Hong Kong. So I think that we can also make good use of our pool of talents in Hong Kong. And as I just mentioned in my presentation and also earlier this morning, law tech, the tech is also very important. And in Hong Kong, we are actively developing law tech. We have collaborated with Law Society and the Bar Associations on a law tech fund, which help try to equip the law firms with more modern technology. And we are also actively promoting ODR and with EBAM as well. And we are also actively at the moment developing the Hong Kong Legal Cloud. So I think all these law tech initiatives can also contribute to the BRI. And lastly, I would just mention that our capacity building effort is also very important. Every year we have the Hong Kong Legal Week, which comprises a series of capacity building and international events that helped to build the capacity of different economies. And for example, earlier this week we have the UNCITRAL Judicial Summit, which is an important event for capacity building, especially for judicial officers. That's in collaboration with UNCITRAL. And just yesterday we have a workshop with the ASEAN Secretariat also on the subject of ODR. So all these capacity building effort is also something that we may also make good use of to contribute to BRI and also the Goal 16 of the UN 2030 agenda. Thank you.
Thank you, Dr. Ding. That's very useful. Actually, I think capacity building is the key in the 21st century. I think for lawyers, like in Hong Kong, like we have 12,000 lawyers as solicitors, and for barristers, we have over 1,500 of them. But I think for capacity building, Law Society of Hong Kong has been like working closely with Department of Justice to make sure our lawyers are sort of gaining the first-hand training and knowledge. But I think it's important, this knowledge will have this open to lawyers along the Belt and Road region. So it's important to have more seminars, more summit, more conferences, so that we can learn more. I think in the 21st century, it's important to be learning. It's always continuous learning. Now, I think we do have one question for Professor Jiao Yun. I think when you mentioned about different channels, platform of dispute resolution. But I mean, given the diversity in social economic context and the culture of all the Belt and Road jurisdictions, but how do one judge whether dispute resolution model, platform or channel is more desirable? I mean, how do you do it? Is there objective criteria to assess it? Thank you.
Thank you, Chair. I think this is a very important question. I think I agree with you that judge cannot know everything. So I think we do need to look at what kind of mechanisms that can be built in the existing platform or channels. I think probably I would use International Commercial Court in China as an example. We can see quite a lot of innovative mechanism has been set up. One, I think, direct answer probably could be the training. Of course, we would like to have very good judges were trained in, have a lot of knowledge. If we look at the rules, we can see that the judge should have a lot of knowledge in international treaties, international law field, international trade and investment. So that's already put down. But the soft skills were how to train. So I think that will be something we look at. The other two areas I think I've briefly touched upon is about the diversification. China also have launched several rounds of judicial reform. Not only we look at the litigation, but mediation, arbitration have already been considered to be very important mechanism for dispute resolution. So that means we are not looking at litigation, but mediation. We also diversify different type of mediation. The coexistence of various type of mediation already being in place. And also the same with the arbitration, the same. So that's the second aspect I think we can see. The third aspect I think I can see from the establishment of the International Commercial Expert Committee from various countries with different cultural backgrounds, with different legal training. So they will be in a position to provide advice, suggestions to the judges or provide mediation services. So I think that's some kind of mechanism has been in place. But in the long run, I think actually we probably will need to look further to some other issues. I can think of probably at the moment 2 points. One point is regarding the law, the nature of law. So whether the law should be considered, or foreign law should be considered as a fact or law. So the judge probably cannot know every type of law, so lawyer can play a much more important role. So judge can be assisted more by the lawyers. Another aspect I think actually is rather important regarding the internationalization of judges. According to the civil procedure law in mainland China, your judge should have a Chinese nationality. But when it comes to the resolution of a BRI disputes, whether we can consider some type of a foreign judge or in different role. So I think that will be some way to look forward. But of course, I think we will have to break through some barriers, I think, in the future development. Thank you.
Thank you, thank you. I think I'll raise the last question to President Kumar. President Kumar, you have a lot of experience in dispute resolution in the international level. Is there some case or story you want to share with us so that we can learn some lesson from that?
Melissa, I will, rather first give you an indirect example. And that is why I say, we have to be very cognizant that capacities and capabilities, both in judiciaries and lawyers, cannot be same at various places. And I will give you one example within India itself. Now, what had happened, that there was a trade-related commercial arbitration held at Singapore between an Indian party and a Japanese party. And the award was given in favor of the Japanese party. But the Indian party challenged the award in one of the states in India where, they could claim jurisdiction. And that court at the district level stayed the award. I was engaged by the Japanese company to go and get that vacated so that the award can be executed. And I can tell you, it was so difficult for me to find a local lawyer to assist me who knew the basics of international commercial dispute resolution. Forget about New York Convention, forget about other things and the Arbitration Act. So this is how I was introduced within India to this difficulty, that there is diversity of capacities, the scale of sophistication in terms of legal services and judicial capacity when it comes to international commercial dispute resolution. Then secondly, when we go and contest an international arbitration, say in Paris. So what is the mechanism? Both the parties, if they are not, ICC, you need not necessarily be a party from France involved or UK. So what happens that you have local law firms engaged mostly, and councils are engaged who are conversant with the ICC thing, and sometimes if I say there is a dispute between India, an Indian party, and Turkmenistan party, and they are having arbitration in ICC Paris. So what you do, the imperative is that the local lawyers will be engaging either a council or a law firm based in Paris. So the real life difficulty which is there is to local lawyers brief those councils, and where the real facts of the case and even the local law which impacts the dispute, you have to brief them about that. And I don't want to take name of particular individuals involved as a case because of the sensitivity, but I can tell you that in my personal experience I found that there was very limited capacity to absorb and also limited inclination to understand the facts and local law. Everybody was happy in driving the arbitration on the basis of broadly acceptable legal principles. So I reached out to the other party also. Both the sides were highly dissatisfied the way arbitration was contested, because according to parties, the facts they wanted to place were never considered, never brought out effectively. And though award came in one party's favor or the other, the level of satisfaction was not there. So that is why my emphasis that the local professions are to be empowered. There has to be capacity building. And as the last speaker, learned professor also, while talking about the commercial court in China, this dichotomy of treating the law as fact, how it is to be addressed so that the dispute resolution is effective, is most important when we look at resolving disputes where at least one of the jurisdiction is not so legally sophisticated in terms of and experienced in terms of resolving international commercial disputes.
Thank you, President Kumar. I really agree entirely with your comments. I think it's important to build up the capacity of all lawyers along the Belt and Road, especially in these emerging markets. And I think today, I must say, we have a very enlightening and fruitful session. The four distinguished speakers, they have shared their insights and experience on how to enhance, strengthen dispute resolution mechanism. And also, we all agree there's a need to put more resources in building capacity building for everyone along the Belt and Road, for the lawyers, for the judges. And at this juncture, I think on behalf of the Law Society of Hong Kong, I would like to express my immense gratitude to Dr. Ding, President Kumar, Ms. Ta, and Professor Zhao Yun. And may I also ask all the audience to join me to give them a big round of applause. It is also my privilege to moderate this enlightening panel. With this session is closed. Thank you, and I hope to see you around soon. Bye-bye.
So thank you very much, our immediate past president, Ms. Melissa Pang, and all the distinguished speakers of the panel for your insightful sharing. We certainly have a much better appreciation of the topic.
It's now about the photo time. So may I invite the speaker to look at the back. There's no need to stand up, just sit tight. And look at the back of the camera. For Mr. Kumar, may you switch on your computer? Okay. Oh, it seems that maybe on the count of three, let's take a photo together. 3, 2, 1, smile. Oh, take your time to.
Okay.
Yep. Don't worry. No
So
rush.
thank you once again, our distinguished panel of guests, while they are seated.
I'm sure we all have some takeaways from all the sessions today. Today's conference will come to an end soon. May we now invite Mr. Fat Ken, Chairman of Belt and Road Conference Organizing Committee of the Law Society of Hong Kong, to share with us his closing remarks. Mr. Ken.
Honored guests, ladies and gentlemen, on behalf of the organizing committee, let me thank all our speakers for their well-articulated and scintillating presentations. I thank each and all 670 plus participants from different corners of the world, without whom there is no conference. I thank members of the Belt and Road Committee and members of the organizing committee, and in particular, Mr. Thomas So, Chair of the Belt and Road Committee, and Mr. Nick Chan, Chairman of the Papers Subcommittee. I also thank the Law Society Secretariat for their tireless work. Finally, I thank the Department of Justice, and in particular, our Secretary for Justice, the Honorable Teresa Jiang Yue-Hua, for including this conference in the legal week. As you know, this is the 4th Belt and Road Conference. At the conclusion of the first Belt and Road Conference on 12 May 2017, 37 lawyers' associations signed the Hong Kong Manifesto, pledging cooperation in the spirit of the Belt and Road Initiative. In the second Belt and Road Conference on the 28th of September 2018, 34 lawyers' associations signed the Law Tech Alliance on cooperation in the age of law tech and artificial intelligence. It is therefore incumbent upon us that we should follow up on the Hong Kong Manifesto and the Law Tech Alliance. I'm glad to say that we have resolved to be proactive to link up all the law associations signing the Hong Kong Manifesto and the Law Tech Alliance, including in the establishment of a Belt and Road office and even a secretariat. Ladies and gentlemen, the theme of this conference, Global Recovery and Harmony Through the Belt and Road Initiative, is the most appropriate as the world is getting out of the devastating COVID pandemic. The Belt and Road Initiative was proposed by President Xi in September 2013. Despite its critics, through these past 8 years, the initiative has demonstrated that it is a plan or movement for peace. Its 5 major principles of coordination, infrastructure, connectivity, unimpeded trade, financial integration, and people connectivity have held true. We live in a critical time where brinkmanship may bring us to the precipice of war. The world desperately needs a workable platform to build mutual trust, understanding, and proper management of differences. The Belt and Road Initiative is such a platform. My friends, the question for the world today is not who is better than who, but how can we better ourselves in a world of peace. So may peace be with you and all of us. Thank you very much for coming.
Thank you, Mr. Kan. On behalf of the Law Society of Hong Kong, we would like to say a big thank you to all of you who joined us today in person or virtually. We would also like to express our gratitude to the Department of Justice of the Government of the Hong Kong Special Administrative Region for the continuous support for the Law Society's events. Hopefully, when the situation allows, we can meet you all in Hong Kong at the 5th Belt and Road Conference next year. Goodbye.
Goodbye.